Hi everyone, I want to welcome you to week 5 of Bioethics 400, Responsible Conduct of Research. And this week we're going to be exploring a special type of collaborative research, thus building off of the conversations we started last week. But we're going to be talking specifically about partnerships between academia and industry. And these partnerships can take any number of forms. It can be something as simple as a contract that an industry group gives to you or your laboratory to do specific analyses or collect specific data for them. It can be a research grant to do sort of less targeted, more creative work. And it would be similar in many ways to a research grant that you would receive from an organization like the NIH or the National Science Foundation, NSF, or it can be something where you're actually collaborating in some ways with laboratories and investigators working within industry themselves. And in fact, there are a number of funding mechanisms that the US federal government has that require that the applicants for those funding opportunities actually be a collaboration between academic groups and industry as well. So what we're going to be doing is we're going to be exploring this sort of special type of collaboration, and we have 4 learning objectives for this week from this lecture and also from the readings assigned to you. By the end of this week, you should be able to understand the differences between academic and industry interests. You should be able to explain the factors behind increasing academic and industry collaborations. You should describe both the benefits and the harms or challenges of academic industry partnerships, and then you should be able to understand the challenges of actually collaborating with industry, either as an academic or wherever your studies end up taking you. And so what I want to do is I want to start with the interests of academia. So as students, you're probably well aware of what these interests are, but traditionally academic institutions are seen as having several specific interests, including, of course, our mission of educating students, the next generation of researchers. We also try to advance human knowledge through research. We promote openness and free exchange of data. We promote academic freedom, free speech and thought. We promote honesty and objectivity. And in many ways, researchers, particularly faculty members in academia, are seen as seeking knowledge for its own sake. Finally, academic institutions, the institutions themselves, have specific interests in meeting their obligations to faculty, students, staff, and alumni, a lot of those obligations obviously overlapping with the specific interests we just went through. By contrast, industry has different interests. And when I talk about industry, really what I'm doing is I'm talking about private companies and corporations. This doesn't necessarily mean for-profit companies. There are a number of non-profit companies that also work within the research arena, particularly in biomedical research, but many of them have specific interests that are more aligned with commercial activities. And this includes maximizing profits and producing goods and services, protecting confidential business information and proprietary interests, imposing restrictions on the exchange of information in order to protect these interests, utilizing knowledge for the sake of profit or, in the case of nonprofit organization, specific practical goals, and then meeting obligations to their stockholders, their customers, and their employees. So you can see how it's quite different from the traditional sort of mission of academia. Now, I think it's important to start with the fact that the number and the nature of academic industry partnerships has increased dramatically over the past almost 4 decades now, and I'll explain why that is in just a few minutes. But this graph, I think, really highlights this radical increase that you see in industry-funded research. So this compares research and development expenditures by sources of funds from 1993 to 2002, so a 9-year period. And you can see that in that time, the U.S. federal government in 1993 spent about $60 billion on research and development, and that was not only research being done in-house within the National Institutes of Health themselves, but also to support external activities through some of these different granting mechanisms. And that increased slightly to about $75 billion in 2002, at least in relative constant 1996 dollars. So it was a relatively modest increase. By contrast, industry reported spending about $100 billion on research and development in 1993, and almost doubling that just 9 years later. Now, not all of that research and development money went into these new academic industry partnerships, and in fact industry compared to federal and state governments is still not the largest supporter of research, academic research through external grants. But the nature of these relationships, these partnerships, is increasing dramatically. And so, and I'll talk a little bit about some of the specific numbers in a few minutes. Now, there is one other category of funds, and that's usually philanthropic organizations, foundations, charitable organizations, etc. But they really are a small drop in the bucket, about $10 to $20 billion a year in R&D expenditures, largely grants and contracts to either academic institutions or other nonprofit organizations. Now, if you look at academic and industry collaborations, you can see that there has been a significant increase in collaborations between academia and industry since 1980. And this is also true for collaborations between industry and federal and state-run institutions. So you're starting to see more partnerships, not only between a university like Clarkson and private corporations or privately owned companies, but you're also starting to see groups like the U.S. Centers for Disease Control and Prevention, the CDC, state-level research facilities like New York State Department of Health's Wadsworth Center, etc. You're starting to see more and more collaborations with industry as well. Federal and state-run institutions are also beginning to themselves set up more and more startup companies, as are academic institutions like Clarkson. And so it has really increased radically, and it currently accounts for $457 billion in economic output in the United States. So that it really is a significant percentage of the gross domestic product of the United States. And this is largely the result of two congressional acts that I'll describe in a moment. And those acts are the Bayh-Dole Act of 1980 and then the Technology Transfer Act of 1980 as well. And so what were those specific acts? Well, the Bayh-Dole Act of 1980, which is also known as Public Law 96-517, and is the actual title of it is the Patent and Trademark Act of 1980. Bayh-Dole refers to the two senators who initially proposed it. What that act did was allow small businesses and nonprofit institutions to retain title to innovations that they made under federally funded research programs. Now, the goal of this act was to promote investment by the private sector in the commercialization of federally funded research discoveries for the public good. The arguments that the policymakers made was that creativity, particularly creativity on the part of academic institutions like Clarkson and their faculty and staff and students, was a national resource that was being poorly utilized. They realized that the patent system in the U.S. was the vehicle which permits the delivery of creativity as a resource to the public, and thus it is in the public's interest to place stewardship of research results, particularly federally funded research results, into the hands of universities and small businesses and allow them to patent their discoveries. Existing U.S. policy at the time was ineffective because intellectual property and innovation were restricted. Usually there was very little allowance for patenting of federally funded discoveries prior to 1980. Rather, they remained in the public domain and usable by anyone. And so the idea was, let's change that. Let's allow researchers and institutions to have an economic incentive to patent and license their discoveries. And it was meant to encourage collaboration with industry and promote the utilization of these discoveries. Now, there were some limitations. You had to disclose to the federal government within 2 months of the invention that you intended to patent, and the universities themselves had to file the patents on the inventions that they elected to own, though they could share those monies with the inventors, that is, the faculty, if they wanted to. Now, the government did retain a non-exclusive license and march-in rights. That meant that the university could patent and commercialize a discovery, but in certain circumstances, the federal government could step in and say, we're going to break the patent, or you have to also give us the rights to use your discovery. Those march-in rights have never actually been used, though there was one moment in 2001 in which the federal government did actually threaten that, and that was when they threatened to exercise their march-in rights regarding the patent for the antibiotic Cipro, which was the antibiotic that was used prophylactically and for treatment during the anthrax attacks in October of 2001. The Cipro patent was actually owned by a university whose faculty member had discovered this particular type of antibiotic, and then it was licensed to the pharmaceutical industry. The federal government felt that this pharmaceutical company was limiting access and charging a lot of money for Cipro at a time when the U.S. government was particularly worried about bioterrorism and wanted to increase supplies and access to this. So they threatened march-in rights, and not surprisingly, the pharmaceutical company in question made stockpiles of Cipro available and reduced the price, particularly the price that they were charging the federal government. So again, the government retains a non-exclusive license to use any discovery and march-in rights. Now, under Bayh-Dole, if you do get a patent, there is the requirement that you can't just sit on the patent, but you actually have to make an attempt to develop the invention. And they also encouraged you to partner with small businesses rather than large multinational companies in terms of granted licenses. So there is the expectation that when you are negotiating a licensing or a marketing agreement, that you give preference to smaller companies. Finally, the products have to be, or at least at the time, had to be manufactured in the United States. So the idea behind Bayh-Dole was to get these discoveries off the shelf without necessarily sacrificing the mission of funding organizations like the NIH or the university. And it also had the idea that this would become a source of income for the university that could be used to support even more research, but also to support some of the other missions of academic institutions. Excuse me. And this was important at a time when federal and state governments were cutting back on the support that they were providing to institutions and expecting students to bear more of the burden and cost of their education through higher tuition. Now, some people did critique the Bayh-Dole Act at the time. They were worried about increased commercialization of the university research agenda. That is, universities would stop focusing on basic science and instead would focus on things that were specifically about commercial opportunities. So you had a trade-off between sort of focus on basic research and commercially profitable discoveries. And there were also concerns that this could be seen as an anti-commons approach to research. Anti-commons refers to this idea of the public commons, that anything that is a public resource should be freely accessible to all members of the public to use. And if the federal government is supporting research, but you're allowing institutions to then commercialize it and license it to private companies, that would go against this idea of it being a public resource. So there was concern about that. That was actually some of the reasons why the legislation includes this non-exclusive license and marching rights for the government. But again, the government has actually never exercised those rights. Now, the second act that came around at the same time is the Technology Transfer Act of 1980. That act, which was also amended in 1986, allows cooperative research and development agreements between federal laboratories and private industry. So what was the response of all of this? Well, by 1990, more than 200 academic institutions, in response to BIE had begun to explore these opportunities and had created specific technology transfer offices to negotiate licensing and marketing agreements with private industry. Moreover, you began to see a rapid increase in the number of patents issued to universities. Prior to 1980, there were only a dozen or so patents per year to academic institutions, prior to 1980 and the Bayh-Dole Act, you only had a handful. But by 1990, the U.S. Patent Office was issuing more than 1,200 patents a year to academic institutions. Around the same time, and in subsequent years, you have seen modifications and amendments to both Bayh-Dole and the Tech Transfer Act. For example, in 1994, Congress extended the maximum duration of a United States patent from 17 to 20 years, increasing the value of patent protection and thus increasing the value of federally funded but university-owned discoveries. And then more recently, in 2011, the America Invest Act shifted the patent system from a first-to-invent standard to a first-to-file standard. So that really changed the way universities look at patentable discoveries, because it used to be that if a university researcher discovered, say, a new antibiotic like Cipro and presented it at a public conference, that would be evidence of first to invent. And so the university would actually have the rights to file the patent. That changed, and so in 2011 you switched to a first-to-file system. So what that means is that the universities now really discourage faculty members from sharing information about discoveries publicly until the university is ready to file the patent, because they are afraid that larger, more well-resourced competitors will actually learn about the discovery, do their own research, and then file the patent first, and so will actually be able to get a patent on a discovery that was actually made by another faculty member at another university. So that's been an important change. So what are the benefits of academia and industry collaboration? Well, obviously, academic institutions receive a financial benefit, and they use that to train students, support faculty and staff, and to fund research projects. So a clear benefit is that academia gets funding and other resources that would otherwise be difficult to acquire. These resources can be used specifically to help students like yourselves learn practical realities, have the opportunity to work in more cutting-edge areas of research, and thus enhance your career opportunities. Now, obviously, private industry gets a lot of benefit here. They receive the benefit of access to intellectual knowledge, particularly in the basic sciences. So they have wider access to the expertise, the facilities, and the equipment that are housed within academic institutions. More importantly, most of the research that industry does or supports is really sort of applied research. So the idea being that they want commercializable products. Much of the research that academics do is much more in the basic sciences. So it's hard to see, for example, how a laboratory at Clarkson University that might be studying signaling pathways in cells that use phosphorylation, how that might lead to commercializable discoveries. But if they patent, for example, the discovery of a new phosphokinase, and it turns out that that phosphokinase is important in some sort of drug discovery mechanism, then it may become a licensable and marketable product. And so private industry really does want to encourage academia to focus on the basic research and will provide material support for them because it is so fundamental to them being able to identify new, say, gene or protein targets in order to treat specific diseases. And this would be research that they wouldn't normally fund because it did not have clear commercial applications. Finally, I would argue that society itself benefits because you have additional support for universities and you also have acceleration of the development of goods and services, and this includes new technologies, medical treatments, and devices. A lot of the things that we take for granted now actually came out of laboratory research that was done within academia, and it wasn't until the Bayh-Dole Act that we saw such a radical acceleration of our development, not only in the biomedical sciences, but also in chemistry, in engineering, in physics, and in technology and computer science. So all of that has been a result of sort of this acceleration of industry academia collaborations. Now, it is important to recognize that obviously, as we mentioned, academia and industry have very different goals. So academia primarily seeks to add knowledge for knowledge's sake, whereas industry primarily seeks profit. You also have differences in information sharing. Academia strives for openness, or at least it did until the recent 2011 change to the patenting system via the American Invents Act, which has sort of put a damper on that openness. But that openness in academia really is in contrast to secrecy in industry, because secrecy is important to protect trade secrets as well as to protect intellectual property. Finally, there are clear differences in obligations. Academia's primary obligation is to those affiliated with the educational institution itself, as well as the government and the community in which it is located, whereas industry has obligations to the government and community, yes, but also additionally has obligations to their shareholders, their customers, and their employees. And so there are clear differences that arise here. Now, what has changed? Well, I already alluded a bit to this about the rapid growth in sort of resources and economic output to the point that these academic industry partnerships are now almost $500 billion in terms of economic output and contribution to the U.S. gross national product. But what you see is that you see a radical increase, as I mentioned, in the number of university-generated patent applications. So prior to 1980, you had less than 250 per year, and in fact, recent studies suggest that the number was in fact much lower, more in the range of maybe 24. Whereas in 2017, you had 14,474 patents granted to universities in that year alone. If you look at financial year 2003, U.S. universities executed 4,516 technology licenses and options. So that is, they took their patented discoveries and they either licensed or gave marketing rights to private companies. And in exchange for those 4,516 licenses and options, they received $1.3 billion in gross license income, and they held equity in 251, or almost two-thirds of the 374 startup companies that were formed around university license technology in that year alone. And if you look at these licenses, options, and income, it increases on average about 10% a year, adjusting, of course, for rapid economic growth or economic decline, depending on if we're a boom or a bust economy. And in fact, as a result of Bayh-Dole and the Tech Transfer Act of 1980, American universities now dominate a global list of the top utility patents. And these are the patents that are awarded to a U.S. university for a process, machine manufacture, or composition of matter. So U.S. universities were the top holder of utility patents globally in 2016. If you look at faculty, almost a quarter of all life science faculty have some sort of patent. And in fact, the median patent holder owns 2 patents. I myself am included in that, even though you guys know me as your bioethics professor and the chair of the bioethics department. Prior to joining Clarkson, I actually used to work in public health research and specifically in HIV transmission and pathogenesis. And I have actually 7 patents, 6 US and 1 European patent for a variety of tests that are used in HIV diagnosis and treatment, and those are licensed to Quest Diagnostics, and for that I do receive a small amount of revenue. Now, revenue such as the revenue income that comes from my patents are often seen as an academic's lottery ticket. Now, in the case of my patents, it's not that lucrative. I'm in all openness and honesty, I only get about $3,000 to $4,000 a year in terms of licensing revenue from my patents, although it is a nice chunk of change that I often use to take my family on holiday in the summer or at Christmas time. But of the faculty members who have patents, about a third of them receive some sort of licensing revenue, and that is 8% of all life science faculty in the United States. The average royalties are a little higher than what I receive, but the average royalties are about $16,500 US per patent. Now, in some cases, again, that patent income can really vary, and in some instances, remember, the university is the organization that files the patent and actually holds the patent rights. So it really depends on what the university grants to the discovering faculty member in terms of ownership share. Not all universities will actually provide a share in any licensing or patent royalties, although most do, because they see it as an incentive to encourage faculty to do research that can lead to these patentable discoveries. So now, universities have other interests in seeking industry partnerships that fall sort of outside the range of the financial, and this includes generation of new knowledge. So, of course, industry supports research, encourages research, and so you see the university aligning that with their goal of knowledge for knowledge's sake. These relationships also give the university the opportunity to create human capital, that is, to create new job opportunities for faculty and staff. It's a way of them transferring knowledge outside the Howard Halls or the Ivory Tower, as it's well known, into the public sector. And then you also have tech innovations, you get capital investment, and then the university helps sort of develop its position of leadership and its influence regionally. So beyond just the financial, these relationships with industry also meet other university goals and interests. Now, there are obviously some problems that arise with respect to academia-industry collaboration, and the primary ones are conflicts of interest. We're going to talk about conflicts of interest in detail later on in this course, and we're going to talk both about institutional conflicts of interest, that is, the financial incentives that faculty members have to do research with with these industry partners, and that can come into conflict with their obligations to other parts of their responsibilities. The more lucrative, for example, a research opportunity is, the more likely or the more of an incentive a faculty member has to knowingly or subconsciously bias their results, change their study design, etc. In fact, there's a really nice study that shows the impact that these conflicts of interest have on research results. And researchers found in the biomedical sciences that an industry-sponsored clinical trial tends to find a positive result, that is, the new drug or device is effective, about 3/4 of the time. If you look at publicly funded, that is NIH or NSF funded clinical trials, the frequency of finding a positive result is much lower, about one quarter to 1/3 of the time. So there's a threefold difference in the likelihood that you'll find a positive and statistically significant effect if the money comes from industry versus a public source. And so some people have argued that that might be the result of the investigators ensuring that the study design or the data analysis methods that they choose are very specific in order to make it more likely that they'll see a positive effect. Now, there can also be institutional conflicts of interest. For example, if Clarkson is offered $5 million to be part of a clinical trial being run by a company like GlaxoSmithKline, that clinical trial obviously has to undergo review and approval by Clarkson's IRB, or Institutional Review Board, the independent committee that reviews, approves, and oversees any research involving human volunteers at Clarkson University. And so there might be pressure upon that IRB to approve a study, even if they have concerns, because of both the financial interests of the institution as well as the status by which the institution's status will increase in the community if it's known, publicly known, that they just received a large grant from a company like GlaxoSmithKline. So there can be conflicts of interest in that regard. There can be research bias. I've already sort of touched a little bit upon this, but it can lead researchers, it can lead institutions to emphasize or focus on research that has more commercial applications rather than the basic science that universities are so well known for. You have increased secrecy in academia. Again, academia has always been known as interest has been in the free sort of generation and dissemination of knowledge, but particularly after you have the American Invest Act of 2011 that changed the patent system, you now see institutions and researchers are less likely to share this information publicly, and so that interferes with the free exchange of information, particularly between collaborating institutions that is so important for scientific advancement. You do have issues and disagreements around data ownership. Those are discussed in detail in some of the assigned readings, and particularly around how to ensure intellectual property. One of the readings, in fact, that I've assigned you goes into great depth into the different sort of approaches that academia and industry use to protect data and assert ownership. I don't want you to have to try to memorize that, but definitely make sure that you skim that so that you understand all of the different types of issues around data ownership and then intellectual property that arise. And then again, and associated with this research bias is the idea that in addition to emphasizing research that is applied, you may also see a direct diversion of university resources from laboratories that do mainly basic research to laboratories that are doing a lot more applied research. So what you can see, that I like this image because it really highlights both the conflicts and the commonalities between university goals and industry goals. So you can see a university largely is looking for knowledge's sake, and is committed to academic freedom and open discourse while it's engaged in teaching, research, service, and economic development. Industry, by contrast, is about managing knowledge for profit. So they don't want knowledge for knowledge's sake. They want knowledge for its commercializable ability. And because of that, they're not committed to academic freedom and open discourse, but instead they really focus on confidentiality and limiting public discourse. And this is all in order to maximize their profits, related to research and development. Now, there is that overlap here, obviously, in this Venn diagram, though, that both the university and industry are interested in and benefit from the commercialization of new and useful technologies. There are also differences in the way academia and industry operate. Some of this, is already reflected in that previous image, but one of the big differences is that in academia, the faculty, the investigators, be they research faculty or teaching faculty, are the ones that largely set their own research priorities, whereas in the industry, the research priorities are set by management. So an investigator who's very interested in neurodegenerative diseases like Alzheimer's disease, working in a university, is largely free to explore any aspect of Alzheimer's disease that he's interested in. Whereas in industry, the researchers, the investigators working within industry really are going to focus on the research priorities set by management. Those are going to be the ones that are really designed to lead to a new commercializable product. And if a particular line of research that you've been engaged in for 2, 3, even 5 years doesn't seem to be profitable, management may make the decision suddenly to stop that particular line of research or inquiry. And in fact, that has been done in Alzheimer's research, where most of the large pharmaceutical companies are now not seeking any new drugs for treating Alzheimer's because their research has proved to be unfruitful. And so instead, they're going to rely on academia and simply licensing new discoveries directly. Academics tend to seek grants, industry seeks profit. Academics are about publishing and open sharing of information, whereas industry likes to keep all of this proprietary. And then academics tend to focus on sharing of information and transfer of technologies in very early stage of the discovery, whereas industry is only interested in sharing information and transferring technologies if they see value from it. So what should you do working in academia, working in a laboratory, if you're going to consider collaborating with an industry partner? Well, you have to look at what are the employment policies of Clarkson University or any institution you're at regarding industry collaboration. You have to understand the policies of intellectual property and technology transfer. Again, most institutions, at least research-intensive institutions like Clarkson, will have an office of tech transfer that is devoted to looking at these issues and will have policies about intellectual property, but will also be the ones to negotiate any tech transfer agreement. You have to consider revenue sharing, not only what is industry giving the institution, but what are you as a faculty member or a researcher getting in terms of that financial benefit, given that the patent itself is owned by the university and not you directly. And then at what level are you as a faculty member or researcher being involved in some of these decisions, right? So things you have to consider, your employer, be it the university, a college, a research institute, owns all of the property rights to any intellectual property that is conceived of or that is discovered as a result of the work that you do as an employee of Clarkson University. And yes, as a student working as an undergraduate in someone's lab, you are bound by these same sort of employment agreements. And this is usually part of your consideration when you either join the institution or when you take a position in a laboratory. Now, it's not just about the revenue sharing, it's also about things like salary, space, other resources that are utilized within the university. And again, it's about ownership and transfer of data, of rights to your discoveries as a faculty member to the university and then outside of the university. And so generally, when it comes to sharing of intellectual property, most companies have the general rule that the company itself owns any intellectual property that is created or licensed to them. So if you are working in a collaboration with an industry partner, you need to make sure that it is very clear who has intellectual property rights and whether or not you are being hired as a consultant, you're receiving a contract, or if you're receiving a grant, because each of those different mechanisms will have a different expectation of ownership of data and of information. You also have to have concern about confidentiality and publication rights, particularly what information is considered to be confidential, and thus you cannot share with anyone outside of the collaboration, even with people within your own institution. There are situations, for example, where if you're collaborating with industry and you develop a new technique or you make a new discovery as part of that industry collaboration, even if that information will be helpful to your friend working in the lab next door, you may not be allowed to provide that information or share those insights with them. So you have to be careful if you're working in an industry collaboration, the types of information that you would normally freely share in things like a departmental lab meeting. You have to ask yourselves about questions regarding freedom to publish. Many companies, as part of sponsored projects, will put limits on if and when a researcher that they are supporting or collaborating with can publish this data or their discoveries in a peer-reviewed journal. Sometimes it can be something as simple as you're just required to give the company a copy of the manuscript before it's submitted to the publisher. Other times there might be a limitation on 6 months or 12 months before you're allowed to publish. There's an embargo on publishing any sort of data that comes out of the collaboration. Problems have arisen in the past, and in fact, some of the discussions we'll have in the discussion forums this week will focus on the problems that have arisen in the past. In general, however, most universities now, as a result of those previous difficulties, won't sign any collaborative agreement that puts a complete restriction on publication. Instead, they'll only allow a limited embargo. So what are some of the issues that can arise? Again, I've already mentioned conflicts of interest and commitment, intellectual property rights, confidentiality, publication rights. Sometimes you'll also have indemnification and limitation of liability. That is, general questions about should something happen during the course of your research, what are you responsible for in terms of both legal and financial consequences? Say, for example, if you're doing an industry-sponsored project and there's an accident in your laboratory, is the university responsible for any injury or damage that occurs? Is the industry collaborator, or are you? So indemnification and limitation of liability is always an issue. There's issues of exclusivity. For example, you might be limited in the types of other research you can do or other consulting or contractual arrangements you might make with other companies. So you have to understand if the contract or collaboration you have prevents you from doing, quote, overlapping or related research for others or for your own interest. There might be language that restricts what you can pursue or what the university can pursue. There are also considerations of the use of university resources in any sort of agreement, including space, equipment, undergraduate students like yourself, etc. And in fact, Clarkson has a committee that looks very specifically at the use of university resources for industry-sponsored or collaborative projects, and they put restrictions on the type of equipment that you can use during the collaboration, as well as the facilities and hours during which you may work. And then finally, there are often tax issues that are related to any receipt of financial benefits that come from things like patents and royalties from other licensing and marketing agreements. Right. So just to give you an idea, close with a case study. So here's an example of valuable research. Imagine that you're a graduate student and you're about to receive your PhD, and you discover that your research is going to be used by a company, and that your mentor has been discussing obtaining a contract to develop the discovery you made as part of your PhD research into a patent. Now you might be told that this is going to occur in the future and you're going to have nothing to do with it. So even though they're going to build off of and patent the discoveries that you made as part of your dissertation research, you will have no ownership rights, you will have no income or royalty rights from that. Instead, you're told that your data earns you the PhD that you've been seeking, and that is the sole purpose of your work. And so questions that I want you guys to consider is whether or not, if you were in this situation, would you have a valid grievance against your mentor for not telling you about the commercial opportunities that they were pursuing? Do you feel like you have any ownership rights to the discovery? Or, since, as your mentor has said, any sort of contract is going to be in the future, so you're going to not have any recourse. More importantly, and I think that this is something to always consider, can you use the knowledge and the data that you garnered from your research in the future? So many of us, when we did our doctoral dissertations, we were exploring research topics that we were interested in and wanted to pursue when we were postdocs and maybe even when we were faculty members. And can we take that information with us? Can we build upon the ideas that we made, particularly once they've been patented and licensed to a private company? We already know from our discussions in week 3 that essentially the university owns rights to any of the data, though they may allow you to take them with you and build upon them. That's just something that you need to go negotiate with your mentor and the university. It gets trickier, obviously, when there's an industry partner involved because of their interest in protecting intellectual property and commercializing any discovery. And in fact, there have been situations in which students or faculty members have run afoul of patenting or licensing agreements that their university negotiated with an industry partner, and actually have been sued for violating patents or have been sued for breaches of confidentiality regarding intellectual property, simply because they built off of ideas that they had worked on that had later become patented. And then, so always consider what can or should you do in situations like this, if any. So with that, I'm going to end, and want to encourage you to read the assigned readings for this week very carefully, because they're going to go into greater detail a lot of the challenges associated with collaborating with industry, as well as some of the ethical issues that arise, whereas the focus of this lecture has been primarily an overview, as well as to give you a lay of the land in terms of the rapid growth in academic industry partnerships. So with that, I'm going to end, and I will see you all online.